Welcome back to the Monday edition of the South African Morning. I'm Gareth Edwards. The Constitutional Court has agreed to hear former President Jacob Zuma's application to set aside its judgment against him. The court, to remind you, found Zuma guilty of contempt of court for defying an order to appear back at the state capture inquiry. It sentenced him to 15 months in prison. That deadline was yesterday. The application will be heard next week, but legal experts say the police remain under order to arrest Zuma within the next 3 days. This after he failed to hand himself over to police. Let's unpack the legal ramifications here. It's a huge pleasure to welcome to the show constitutional law expert Rebecca Sibanda. Rebecca, good morning to you. And let's just pick up on that last point if we can. I think many South Africans this morning are now curious now that the former president has applied for this court order to be rescinded. That is different to the order being challenged and suspended, isn't it? So as of now, essentially the police can and constitutionally should still arrest the former president. Is that correct?
Good morning, guys. And yes, you are absolutely correct. The process with an application for rescission and the process for a review or an appeal are much different. So where once an applicant files papers for the review or the appeal of the matter, that whatever order is standing is suspended until the resolution of the application for appeal or review. In this case, however, because this is the apex court and there is no option for application for appeal or review, the order of the Constitutional Court stands and must be, followed through by those that are responsible until such time as a stay of, the committal for arrest is obtained. So I think, and I haven't read the papers that have been filed at the Pietermaritzburg High Court, I think that the former president's lawyers are in the process of trying to appeal for an interdict that would then stay the committal of his arrest.
But as it stands right now, the police are obligated to arrest the former president as it now stands. So you're telling me that because it's the Con Court, there is no grounds for appeal whatsoever. If that is the case, and that indeed is the case, why would then be an urgent application for this to be rescinded only be heard on the 12th of July? Because surely the former president is executing his democratic right to apply for this to be rescinded, but it's only going to be heard about 7 days later. The timing doesn't make sense to me.
I think, and there's been spirited debate in the legal community about what all of this means. And I think the first thing that you've pointed out is very important, that if it is indeed an urgent application, then it should be heard with, the urgency it deserves, especially considering the fact that there is a standing order for his arrest. And I think it's also important for us to remember that we are currently within a pandemic, and level 4 restrictions mean that a person who is arrested doesn't get any visitors, and I think that includes the lawyers. So if he is arrested and the urgent matter is only heard on the 12th, then how does he prepare for the application? So I think it's a lot of moving parts in this case. And one thing I think that is consistent that you will hear from all legal experts or people in the community is that we've never been here before. So we also are experienced this with the novel, attitude. We've never experienced a situation where the apex court's judgment is being challenged, and we've never seen a situation where a judgment is being challenged along with, an interdict being applied for. So these are all many moving parts, and we are also experiencing something like this for the first time in the legal community. So it would be interesting to see what happens in the Pietermaritzburg High Court, and I also think it's important to note that the Commission itself has filed papers to oppose what's going on in the Pietermaritzburg High Court. So there's two outcomes we're now going to have to look out for.
If I could just pick up, I don't want to discuss outcomes necessarily. We don't quite know what the court is going to do, one of two. I'm curious to understand about let me call it the ranking of the courts. If the Constitutional Court, quite rightly, is the apex court, this appeal for the order to be rescinded is going to the High Court. I would have imagined that the High Court can't overturn or backtrack on what a Constitutional Court order has been made. How does a High Court, in this case, go against, potentially, what the Con Court has said?
So I think that we need some clarity. There are two processes that are underway at the moment. The first is the application for rescission, which has been filed with the Constitutional Court. That's the first process. The second process is that, like I said before, because this is not an application for appeal or review, there is no automatic suspension of the Constitutional Court's order for committal. So the second process that's underway, which is what I believe is happening at the Pietermaritzburg High Court, is an interdict, an application for an urgent interdict to stay Mr. Zuma's arrest. So there's two court processes that we're seeing. And I'm thinking that the reason the former president's legal team has approached the Pietermaritzburg High Court for the staying procedure is that is the province within which the former president will be, arrested and kept in during his 15-month sentence. So there are two processes underway. The rescinding or the process for rescinding is taking place in the Constitutional Court, as it rightfully should, and then the application for an urgent interdict to stay the arrest of the former president is taking place in the province in which he is going to serve his sentence.
Final question to you, and I know it's a difficult question to answer as briefly as possible, but as briefly as you can. But of course, please make your point as clearly as you'd like to. So as I wrap up, so as of today, before this application is heard on the 12th of July, the SAPS are allowed, it is legal for them to arrest the former president. Is that correct?
That is accurate. So we have a 3-day window that was afforded by the acting Chief Justice to allow members of the SAPS right up to the Commissioner and the Minister to ensure that Mr. Zuma is arrested. So pending any outcome in any court proceeding, he can be arrested before that. He can be arrested right before the judgment is handed out. So from today until Wednesday, former President Zuma may rightfully be arrested and committed to serve his sentence.
I appreciate your time. Constitutional law expert Rebecca Sibanda, such an important last answer, wasn't it, for the week ahead?